is certainly one of the areas that is most significantly going to be impacted. So I think there are many areas under procurement law that will, I think, be largely business as usual under the new legislative scheme. This one is not one of them. This one, I think, is going to be fundamentally different. So it's quite interesting to look at it. So I thought in just sharing some thoughts with you, and then for me, more importantly, hearing what you think about the proposals on the table. I'll just give a little bit of background to how did we get to this point. And I think it is quite important to give this little bit of background to preferential procurement from a regulatory point of view, because I often find in conversations around reform of this area, there's a lot of uncertainty about how this regime fits together. So I think it is quite important just to do this little bit of background, and then we can talk about the bill. So I'm going to be quite quick about the background. We all know that the Constitution in Section 217 gives us the basic principles that our public procurement system must comply with. But then very importantly, it does this additional thing, and that is in subsection 2 and 3. It gives us this framework or this authorization or mandate for using procurement for policy purposes. Now, this is quite important because in many legal systems around the world, there's a lot of debate about the extent to which you can use public procurement for all kinds of policy purposes. That's really beyond just the core function of acquiring the goods and services you need to achieve something else, whether that's even a legitimate use of public procurement. In South Africa, we don't have to enter into that debate because our Constitution explicitly says that we may do so. It grants an explicit authorization in Section 2172. So this is the starting point. Very importantly, 2172 then authorizes basically two things. And I think we often forget that when we have these conversations because we've really only focused on one. So 2172 says that this system under 217 allows for two things, apart from the general whatever you want to do under the principles. It allows for categories of preference in the allocation of contracts. Now, just look at that for a moment. 2172A is specific in terms of the mechanism. So it talks about preference. It is not specific in terms of the subject matter. So it doesn't tell us preference for what. That is left open. It just allows preference in the allocation of contracts. And then secondly, B, the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. B does the exact opposite from A. So B is not specific in terms of the mechanism. It doesn't tell us what mechanism you should use. It only gives us the purpose, the substantive policy, and that is the protection or advancement of historically disadvantaged people. So under B again, we know what the policy objective must be, but it leaves the tool, the mechanism, completely open. And I think that's very important to remember, that the Constitution allows for both of these type of things. But then importantly, the Constitution in 2173 says that national legislation must prescribe a framework, and that this use of procurement for policy purposes, as envisaged in 2172, must be done in terms of that national legislation. Now, this is important because it tells us who is in control of creating the framework. Note also an important interpretive message that we get from Section 217 is that the framework must be created in national legislation, and then entities must implement in terms of that framework. Note specifically the word used in Section 217(2). It says subsection 1 doesn't prevent organs of state or institutions from implementing a procurement policy providing for. It does not say in 2172 or anywhere in 217 for that matter, that organs of state must determine or create this policy that is meant to give preference or advance or protect HDIs, right? That is left open. The most that we can get from 217 is in sub 3, where it talks about this framework that must be created. An important point also just to note, it's not on the slide, but it's important to note that the Constitution defines legislation in a different section. And importantly, that definition includes regulations, right? So when 2173 talks about national legislation, it is not restricted to primary statutes passed by Parliament. It includes regulations made under that statute. So that's an important point to note as we look at the new bill. Okay, so that's our background. We know, of course, that 2173 was then originally enacted in the form of the PPPFA, the Preferential Procurement Policy Framework Act in 2000. And this is the framework that was meant to give effect to 2172. And we also know that in the PPPFA Section 2, it says that an organ of state must determine its preferential procurement policy and implement it within the following framework. And then it gives us the very familiar price preference scheme where the 80, 20, 90, 10 comes in. 80 or 90 for price, 10 or 20 for preference. That's in the statute, in the PPPFA itself. The Act itself then grants the minister the power to make further regulations to give effect to this statute. And the minister has done so extensively, right? So between 2000 and now, we've had 4 sets of preferential procurement regulations, 2001, 11, 17, and now under 22. And we've had this progression of preferencing under these sets of regulations over time, and we've almost now come full circle in this period. So under the original set of regulations, the 2001 set, it was really quite open-ended. It was left to procuring entities to really give substantive content to those 20 or 10 preference points. It just said a maximum of 20 points may be awarded to a tenderer for being an HDI and or subcontracting with an HDI and or achieving any of the specified goals stipulated in Regulation 17. And Regulation 17 was basically then just capturing the RDP program as also referenced in the statute. But beyond that, it was up to entities to decide how they're going to give content, how they're going to calculate these 10 or 20 points. The 2001 regulations then a decade later gave way to the 2011 regulations, which completely changed the approach. So from this very open-ended approach where it said organs of state can really just determine, we went all the way to a very, very closed approach where the regulations then simply just prescribed this matrix. It just said, look, you use the BEE certificate of the bidder, you just go to this matrix, and it is a mechanical exercise based on the number of, or the status as certified. You just add the number of points, no discretion whatsoever. So the 2011 regulations really removed any discretion. It became a mechanical exercise how the 20 or the 10 points to be calculated. That was then in turn replaced by the 2017 regulations, which retained this idea of a mechanical calculation of the 10 or 20 points, same or very similar matrix, but it then added 2 further elements to preferential procurement. And that is the so-called pre-qualification, which was really just a set-aside mechanism. It allowed contracts to be set aside based on these particular criteria, and it provided for mandatory subcontracting. reserving a part of the contract for prescribed subcontractors. So it just enlarged the number of tools while retaining the mechanical approach to the 10 or 20 points that the statute refers to. And this set of regulations that was then challenged in the Afri-Business case, and which resulted in the Constitutional Court February last year holding that the 2017 preferential procurement regulations were unlawful. They were invalidated them. And it's very, very important to note the basis upon which the Constitutional Court held the regulations unlawful, because that has got significant implications for where we can go now under a new regime. And the most important point to note is that this Constitutional Court, unlike the Supreme Court of Appeal, the Constitutional Court decided the matter squarely under the statute, under the PPPA, and really did not go into the constitutional question. The Supreme Court of Appeal went into the constitutional question. It dealt with Section 217. The Constitutional Court not. Constitutional Court eventually decided this matter. This is the final binding judgment, right? So it replaces the Supreme Court of Appeal judgment. The Constitutional Court decided this matter on a much narrower basis. And it simply held that under the PPPA, under the statute, the minister does not have the power to make regulations that prescribe to organs of state how they must calculate their 10 or 20 points under the Act. That the Act leaves that to organs of state. And when we quickly go back to the Act, you will see that, right? So the Act says in Section 2.1, an organ of state must determine its preferential procurement policy and implement. So it's that use of the word determine in Section 2.1 of the Act that the court said answers the question. It means that the power was granted by the statute to organs of state to determine their own content within the framework. That means the minister cannot also do so. The minister doesn't also have that power. The minister's got further powers, but he doesn't have that power. And that was the basis upon which the regulations were held to be unlawful. And this is what gave rise then to the current regulations. Before we quickly look at the current regulations and then go to the bill, it is important just to note that the Constitutional Court made one remark, the majority made one remark around the Constitution and the content of the 2017 regulations that I think is very important to take note of. And you find that in paragraph 116 of the majority judgment, where the Constitutional Court said, happily, both the first judgment, that's the minority judgment of the Constitutional Court, and this judgment, that's the majority judgment, meaning that's the binding judgment of the court, and indeed the minister, understand the impugned regulations to do what is envisaged in Section 2172 of the Constitution. I think this is an important remark, because in this remark, the court basically tells us that the content of the 2017 regulations is fine in terms of the Constitution. The court is giving us a signal that what those regulations in content, in substance did, was exactly what 2172 envisages. The problem was the way in which these regulations were made. It was made by an actor, the minister, that didn't have the power. So it was a formal defect, not a substantive defect. I think this is very important, especially when one compares the Constitutional Court judgment with the Supreme Court of Appeals judgment, and especially when we think about what a new regime could potentially look like under a new statute. So I think this is something important to bear in mind. And then, of course, we know that the judgment gave rise to the current set of regulations, the Preferential Procurement Regulations 2022, that came into operation in January this year. And we're really back to the 2001 regulations in the sense that it's now completely open-ended. The regulations basically says nothing about, or very little about, how the 10 or the 20 points must be determined. The 10 and the 20 points remain, it's in the statute, but how you give content to that 10 or 20 points. In other words, what you look at to determine the preference points to be awarded to a bidder is up to the organ of state as determined by its own policy and as set out in the tender invitation. And you see that the regulations now simply says that the tender document must stipulate how these preference points, the 10 or the 20, are going to be calculated with reference to these specified goals. It defines specified goals, but these are really just the definitions we get from the statute itself. Importantly, it's not a closed list. So when you look at that definition, you'll see it says it may include contracting, blah, 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 blah. So it's not limited. It doesn't say it only means the following. And that's exactly the wording of the statute. But it's now up to organs of state, each and every one, to define their own approach to how they're going to do preference points, how they're going to calculate the 10 or the 20. So that's where we are at the moment. And it's against this background that we are eagerly anticipating the new regime. And this is where the bill then comes in. Now, the starting point of the bill in terms of this topic, targeted procurement, is what we call the long title of the bill. Really, it tells us what's the purpose. It's the first bit of text under the title, the heading. And the Public Procurement Bill's title says it's to regulate public procurement, to prescribe a framework within which preferential procurement must be implemented. So the bill is very clear that its intention, and when Parliament passes it, Parliament's intention is to fulfill its mandate under Section 2173 of the Constitution. So this is it. The bill explicitly tells us this is what this piece of legislation will be doing. It will be the national legislation that provides that framework for implementing Section 2172 of the Constitution, right? So it's very clear. The second critically important point to bear in mind is the repeal section. So this bill proposes to amend and repeal a number of other statutes. And there's a whole long list in the schedule. The most important one for us to note is this one, because the bill tells us that it will repeal and thus replace the entire triple PFA. So this is important to bear in mind when we have this conversation. Once this bill becomes an act, the triple PFA will completely and utterly disappear. It will no longer exist. It will be a thing of the past. So this entire framework of 90-10, 80-20, preference points versus price points, all of that will be gone. It will no longer exist. So we are really starting with a clean slate